So what I'll do is I've received a list of questions that you all actually had for your CPC exam. I have tried to break it down into question wise itself, going by the provisions of the CPC and what you can actually touch upon. I don't want to go too much into reading the whole section or too much into case law because that's something which you all will do in your individual study for the actual exam. But here, if I get a brief idea as such, that will be a little more helpful. And in case anybody does want to participate in the middle, then you're obviously more than welcome to do so. If you have a doubt in the middle, you can ask, or else you can probably put them in the chat box and Malvika ma'am can tell us about them at the end. So I'll start with what the first question is. The first is, what is res judicata? When can it be applied? So now res judicata, in general, you need to look at section 11 of the CPC. It defines exactly what res judicata is. In very simple terms, it means if something has already been decided in one way or another between a suit between the same parties or between parties under whom they are claiming under the same title, then a court is not supposed to actually listen to a suit when the same thing is substantially raised for a subsequent time. So if you read the section itself, also it says that no court shall try any suit or issue in which the matter directly and substantially in issue has been, again, once again, they repeat, directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such a court. So in that sense, what you understand from this is that a suit which has already been instituted prior to this one, dealing with the exact same um, circumstances, facts, or issues between the parties in dispute. So the parties also are the same. There are 8 explanations given in this section itself to actually explain what you mean by former suit, what is a bona fide litigant supposed to do, what is the meaning of an issue that has actually been heard and finally decided. So those are the explanations which are given, which if you read through them once, it will give you a clear explanation of what res judicata means. And this is actually very important because the difference between section 10 and 11, 10 is also something which we'll come up on in one of the subsequent questions. This is something very often asked. The difference between a new suit being instituted or a stay of a suit being heard itself. So therefore, understanding what res judicata means versus separately what we'll do as res sub judice later is important in that aspect. So that is res judicata. You can refer to section 11 for that. Now, the second question was state the provisions regarding transfer of cases. So now, with respect to this, the sections actually that are in relevance to these provisions are from 22 to 25. So if you refer to the CPC, these sections, you all can do it side by side also with the CPC open while we're going through it. So 22, if you see it reads as power to transfer suits, which may be, okay. So 22 says the power to transfer suits, which may be instituted in more than one court. 23 says to what court an application lies. 24 talks about the general power of transfer as well as withdrawal. And then 25 says power of Supreme Court to transfer suits. So touching upon a little bit of these in basic. Now, the first one, which is section 22. Now, if a suit can be instituted in 2 or more courts, and it actually has been instituted in one of these courts, then a defendant, obviously the person who it is actually filed against, after giving notice to other parties in the suit, meaning the plaintiff as well as the other defendants, he can try at in all cases where such issues are settled to have it transferred to the other court. Now, this other court also has to be one having jurisdiction, one before whom an application is made, and of course, this has to be at the earliest possible opportunity. Now, the reason why all of this comes in is because when a suit is filed, if say there's more than one defendant, if it's only one, then a transfer in that sense will not require a notice to the other defendants. It will need one to the plaintiff that I want this transferred and an application in furtherance of that made. Whereas 23, when it says to what court an application lies, and 22.1 specifically refers to 22. It explains the provision for filing an application under 22, where it says whether several courts having jurisdiction are subordinate to the same appellate court. An application under section 22 shall be made to the appellate court. Then, where such courts are subordinate to different appellate courts, but one high court, then the application is made to the high court. Or separately, when you are subordinate to different high courts, an application shall be made to the high court within whose limit the jurisdiction of the suit is situated. So if you see, the application, of course, has to be made to the court which has the highest jurisdiction amongst all of these courts, which is why 1, 2, and 3 has this separate distinction, where 1 clearly says about if there are two subordinate but one appellate, you go to appellate. Same way, if there are two appellate but one high court, you go to the same high court itself, and so on and so forth. Now, 24 is the general power of transfer as well as withdrawal. Now, for any application that is made with the notice to the parties, as we said before, and anyone is wanting to be heard or the court on its own motion after taking such a notice, then they can do two things. 22, 24A, sorry. A is transfer the suit, B is withdraw the suit. So based on what application is made, under A, you can transfer any suit, appeal, or any other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try and dispose of the same. So the High Court or District Court, 24 makes it clear that High Court or District Court is given this power. A is to transfer any suit to any court subordinate to it. B is to withdraw any suit that is in any in like as in going on presently in any court subordinate to, and to try and dispose of the same or transfer the same to another subordinate court or retransfer the same for trial to the court from which it was withdrawn. B has three stages in it. Sorry, not stages, three different options of transfer in it. Now, 24.2 has the description of when a suit has actually been transferred or withdrawn under one. Then what happens? And 24.3 actually explains the meanings of courts under this, as well as the meaning of what a proceeding is. So the proceeding includes one for execution of decree. So it doesn't have to be only your original proceeding to attain the decree. It can even be a proceeding which is in execution of it, which is why it clearly says suit, appeal, or any other proceeding. So that also has to be kept in mind. And then 25, as the section reads itself, it says power of the Supreme Court to transfer suits. Now, again, when you read the section, it will say the similar things. There will have to be an application from one party. There will have to be a notice given by that one party to all the other parties. That notice will have to be heard. And then obviously it has to be in an expeditious manner. And after all of that is done, if it is found that it is for all of these purposes and to reach the ends of justice expediently, then it can direct that any suit, appeal, or again, any other proceeding be transferred from a high court or civil court in one state to a high court or civil court in another state. That is what 25.1 says. And 25.2 says that such applications have to have an affidavit and so on and so forth. Of course, the courts which the Supreme Court is actually transferring cases to is in that sense bound to take up that application too, for the reason that the Supreme Court has actually said that such a case has to be heard by that relevant court. But in situations where the Supreme Court can find that a case has been registered in one high court and an application to get it transferred is something that is frivolous or vexatious, then in that sense, the Supreme Court actually can order the applicant to actually be paying costs as well. And subsection 4 over here says that that sum should not exceed 2,000 rupees or as it considers appropriate in the circumstances of the case. So, of course, such kind of transfer applications are also met with caution. And in that sense, since again, it increases the entire load of litigation. Once a suit has been instituted, you know that will take 10, 15 years. Now, when the middle transfer application comes in, so it leads to increased litigation and increased years as well. So that is what the second question will be with respect to transfer. Now, here, the third question says the scope and object of res sub judice, which is what I sort of touched upon in the first answer. Here is the difference between section 10 and section 11. In 11, we saw what is res judicata, meaning something that has been finally heard and decided cannot be instituted again for that same cause of action between those same parties. Now, section 10, on the other hand, which is res sub judice, 10 reads as stay of suit. Now, this means a suit when it is initiated and it is actually pending the proceedings and the trial, then no court can proceed with the trial of any such suit in which an issue has also been directly and substantially an issue in a previous instituted suit between the same parties. I'm just going to read the section once clearly. It says, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties, or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in India having jurisdiction to grant the relief claimed, or in any court beyond the limits of India established or continued by the central government having like jurisdiction, or before Supreme Court. So basically, this means if a suit is currently in existence and pending litigation before a particular court, you cannot file a suit for the same thing in another court. Which is why when you're coming to practice later or in your internships, if you read a particular plaint, you will notice towards the end there will be one sentence which very clearly says, no suit for the same reliefs has been filed or is pending before any other authority of law. That is a statement that you make because of this particular section. You cannot have two suits filed for the same purpose in different courts of law. A subsequent one which is filed will have to be stayed. And that's the first defense that a defendant will actually take up in their written statement or in their reply if there's, say, a interim application filed with the suit. So that's the difference between these two, which is very important. Now, moving on, the fourth question says, what are the necessary elements of the plaint? When can it be rejected? Explain. So this basically question refers to Order 7 of CPC, which talks about plaints. The entire order talks about plaints. Within that, Rule 1 to 8 talks about the particulars of a plaint. Rule 9 talks about the procedure for actually admitting a plaint. And rejection comes later, which is Order 7, Rule 11. So now going through Order 7 itself for a better understanding. Plaint. So now Order 7, Rule 1 to Rule 8, as we said, has various stances of the particulars of a plaint. But Rule 1 itself is the exact particulars that have to be contained within a plaint. Now, this has from A to I, which says name of the court. I hope you'll have the CPC open also side by side. So you will see it says the name of the court, the name, description, place, residence of plaintiff, same way as of the defendant, so far as they can be ascertained. Now, the reason for this is because you need to obviously send a notice to the defendant. So even their details are necessary because you're filing the suit against them. Then D says if the plaintiff or defendant is a minor or person of unsound mind. So this goes on the aspect that only a person with a sound mind who is able to understand and know why the case is being filed is able to file it. Then E says the facts constituting the cause of action when it arose. F is the fact showing that the court has jurisdiction. G is the relief. H is whether the plaintiff has allowed a set-off or relinquished a portion. I is a statement of the value of the subject matter of the suit for purpose of jurisdiction and of court fees. So if you see A to I, though it is listed like this, if you just understand it from a basic manner, everything relevant to the case, as well as to the court hearing the case, as well as to the parties filing the matter and who the matter is being filed against. All of these things together have to come into a plaint. That is basically what A to I says. You need to give proper details of the person filing, of the person against whom it is filed. You have to show that the court has the jurisdiction. You have to show all the facts of the matter. You'll have to show, as we said before, you have to show that the same suit has not been filed elsewhere. And again, a statement on your actual damages being claimed and why you are claiming that. And importantly, it also says whether you've relinquished a portion of the claim. Reason being that, say, if you have a case for example, 1 lakh, if you've either relinquished or you've set off, say, 50,000, your suit should be instituted only for that remaining 50, with a statement being made this way. You file a suit again for 1 lakh, then basically you are claiming more than you have already, more than you actually can claim and are legally entitled to. It's the first thing the defendant will bring up in their reply, and it's also something which you will be guilty of suppressing material facts for. So in short, you can understand it this way. Everything that is material to be put in the plaint is what constitutes the particulars of a plaint. Separately, Rule 2 says in money suits what should come. 2A is when interest is sought, what should happen. So, of course, the rate, date of taking it, the date till which you are claiming, the total amount of interest as per the date on filing the suit. And after filing the suit until, say, there'll be a statement that will be made saying until filing of the suit, until recovery. So the interest should basically continue from the period you file the suit till you actually recover your money as well. Then there are state amendments in the middle. Then rule 3 talks about if the subject matter is immovable property. 4 is when the plaintiff is suing as a representative of somebody else. 5 is the defendant's interest and liability. 6 is the grounds of exemption from limitation law. So, for example, if you have filed a suit after the limitation period is over, we'll come to that later on as well, then you would have to exactly mention that as well. 7 says the relief to specifically be stated, and 8 is the relief founded on separate grounds. So, for example, if you are claiming reliefs on two separate grounds, you have to separately and distinctly state them. So again, if you see 1 to 8, though 1 says the particulars which we read out first, even right up till 8, if you notice, it is basically just saying everything relevant and material has to be disclosed, each and everything. So if you understand it from that aspect, it will become easier to be able to relate to what this says. Then the next part of that question was on rejection of a plaint. Now, rejection of a plaint, if you see, it is Order 7, Rule 11. Now, this is one of the, if I can say, most common applications that is filed in response to a suit. There are many reasons why you can file it. I'm sure you all must have done some internship somewhere or have read a little bit about it. If, say, a suit is filed in the wrong jurisdiction, um, or it is filed against a particular party who is not actually party to that suit, or if you have missed out on adding a particular party, then these are things which you can actually file a Order 7, Rule 11 application to reject the claim. So just reading out a little bit of Order 711, you all should read it two side by side. It says clearly the plaint shall be rejected. There is no may over here. It is a clear case of shall be rejected. A, when it does not disclose the cause of action. I mean, of course. B, if the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation, fails to do so. Now, this can mean that, for example, if you have filed a case for 1 crore, and the court fees is X amount to be paid. You have paid 0.7x, you've not paid the whole amount. Or, for example, if the property that is valued in this case is 1.5 crore, but you've made a statement saying that the property is valued at 75 lakh, you have undervalued your suit, damages wise as well as the relief wise. So, in that sense, if your suit is undervalued, the court, that is known as a curable defect, is the way in which you can pay that additional amount, or you can make that amendment and cure the defect that exists. But if you fail to do so, then the court shall reject your plea because you've been given the opportunity. Then C, if the relief is properly valued, but the plaint is returned upon paper insufficiently stamped, and the plaintiff, after being given the opportunity, again fails to do so. So this is again if you value it properly, but you've not stamped your papers enough. So in that sense, you get the chance, again a curable defect, but you fail to do so. Then D, where the suit appears from the statement in the plaint to be barred by any law. So again, as A itself said, no, sorry, I had mentioned actually, if you have limitation, then you have to make that statement. So if your suit is barred by law, the other side will straight file a 711 saying that this is barred by law. And F, where the plaintiff fails to comply with the provisions of Rule 9, which basically deals with civil suits and how they are to be filed, tried, the entire provision. We'll come to that also a little bit later. So these are the grounds on which a plaint can actually be rejected under Order 7, Rule 11. Yes. And there's a proviso which is mentioned over here, which, which says that provided that the time fixed by court, this is again for that curable defect point, for the correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause of an exceptional nature from correcting the valuation or supplying the requisite stamp paper, as the case may be, within time fixed by court, and that refusal to extend such time would cause grave injustice to the plaintiff. So even here, though we have said from Rule 1 to 8, as we said, everything material has to be mentioned at the filing stage itself, you get this chance to cure your defect if you are able to show to the court that, one, there was some sufficient cause or reason which the court will actually record in writing for why you have been this thing. And if the court finds that if you are not allowed to cure this defect, it would lead to grave injustice against you. So that is the aspect of plaints as well as the rejection of a plaint. So that explains question 4. Now, question 5, discussing the different mode of service of summons. Now for summons, you can refer to Order 5, which talks about issue and service of summons as a whole, and also Section 28 and 29. So we'll go through section 28 and 29 first. I'm just opening my CPC also side by side. Yes. So 28 is service of summons when the defendant resides in another state, and 29 is service of foreign summons. So now 28 basically talks about if a particular person is staying in a state outside the jurisdiction of where this case has actually been filed, then it says that the court to which summons is sent shall, upon receipt thereof, proceed as if it had been issued by such court, and then return the summons to the court of issue, together with the record of any proceedings with respect to that. And at the same time, if your language, because you have different states in India, we have different languages, of course, across. And for example, even within our own actual parent states, for example, if there's a case filed in the Bombay High Court, though the language of the state in that sense is Marathi, once you file it before the High Court, you have to have a proper English translation along with it, for the simple reason that though the state language is Marathi, the language of the High Court is English. And of course, you have a lot of judges who may not be from here. Your Chief Justice, for example, is not supposed to be from, I mean, it's a general practice has been that the Chief Justice is not from the same parent High Court. So in that sense, you understand how important language can be, which is why 28 clearly says even for summons, when you're actually serving somebody, which means you are sending your case and filing proceeding to the defendant against whom it has been filed. Same way if the defendant is filing any application in response to it or a reply in response to it, they have to serve as well. So service of summons will not happen then. Summons is served by the plaintiff only to the defendants, but service in general obviously happens both ways. So now 28.3 specifically says where the language of the summons sent for service in another state is different from the language recorded, then the translation will be sent in Hindi, where the language of the court is issuing the summons is in Hindi, or in Hindi or English, where the language of record is is other than Hindi or English. So then accordingly, you have to serve it with the requisite language of that separate state. Then we saw that at the same time, you have to look at Order 5, which talks about your issue and service of summons as a whole. So you should turn to Order 5 of the CPC. Yes. So Order 5, issue of summons, one itself says summons. Now, if we read the first 5 lines to understand what you mean by summons, it says where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of issue of summons. Now, from this, you understand what summons means. In English sense, basically summoning someone means you're calling. Over here also, it means if a suit has been instituted by somebody, the summons may be issued to the defendant. So you can see clearly here, summons goes from plaintiff to defendant, flows in that way only, to that defendant to come, appear, answer the claim, and to file his written statement if he has one to file within the 30 days that is prescribed as per the law. So that is the basic meaning of what summons is. There are obviously each state there's a state amendment within it for Jammu and Kashmir and other union territories. Then when you go further, you see the copy of plaint annexed to summons, which means your summons is to call the party to actually represent themselves and appear in court. So it naturally flows that what you have filed, your proceedings, as I said before, have to be sent along with the summons. Then under sub rule 3, the court may order the defendant or plaintiff to appear in person, which means not just a advocate representing them, but the person to appear themselves in the court on that day which is specified. And separately, 4 says that no party to be ordered to appear in person unless resident within certain limits, which means you cannot be ordered to actually appear in person unless you live within that certain limits. But there's a separate thing which says without such limits, but at a public place less than 50 or less than 200 miles distance from the courthouse. Now, I mean, you can be asked to appear in person, you can be summoned to court, you can be brought by police assistance also. But in general, if you are not within the local limits of that jurisdiction, and in any case you have an advocate representing you, then party being called in person as such is not a practice that happens very often. It is required, say, for example, when say consent terms are being entered into, or of course cross-examination is happening. At that time, they are really required over there because the judge will actually state to prove that it's been actually signed by them. The judge can actually ask them once that have you signed this? Do you agree that this is your signature? In those cases. Now, sub rule 6 says fixing a day for appearance. 7 says summons to order the defendant to produce documents relied on by him, which goes into the first point, which said that him to actually file his written statement and his responses to it. And 8 says on issue of summons for final disposal, the defendant is to be direct to produce his witness as well, who his witnesses are to prove his case for himself. Now, after this, the remaining sub rules 9, 9A, and 10 till 14, 15, 16, 19, all of them, in fact, until 20, in fact, talk about the mode of serving someone. So if you see, the heading itself says service of summons just above rule 9, sub rule 9. It says delivery of summons by court. So if the court has to send it, then what is the procedure? Summons given to a plaintiff for service, then mode of service. Then if there are several defendants, then the summons will be made on each defendant. Then 12 says summons to be on defendant in person when practicable or on his agent. So either you serve it on him directly or his agent. Then service by someone whose defendant carries on the business, then in charge for suits of immovable property. So there are various ways in which the service actually happens. And then sub rule 20 is substituted service. Now, substituted service over your order 5 rule 20, this is important simply because in court, many times you see that a particular defendant is not able to be served. There are various reasons for this. One can be either they just refuse to accept the service, or two, say their location cannot be found, or three, they are not residing there anymore, or for example, if they have passed away. So then serving them in that sense does not become possible. In these cases, the court orders a substituted service, wherein there are two, three pre-requirements for this. One, you have to prove to the court that you have actually attempted to serve a person first. So you have to show on affidavit of service that you have tried to serve them. This is what the remark that the entire postal receipt has come back with, or the person has passed away. Or for example, it says that he has left from this premise. So that affidavit of service, which proves your attempt to serve, has to be given to court first. If the court finds that you have attempted to serve but have been unable to serve for one reason or the other, an application is made by you under this provision, Order 5, Rule 20, for substitute service, which means you are allowed to serve the proceedings in a place which is visible to public at large, through which it is assumed, in very basic sense I'm explaining, through which it is assumed that that particular person will be able to see it, or in that sense is so public that it is public knowledge and he ought to know about it. So that's why it says in 1A specifically that it can order service. So a court acting under sub-rule 1, which explains substitute service, it orders service by an advertisement in a newspaper. The newspaper shall be in a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided or carried on business or personally worked. So in that sense, you publish it in a newspaper, most likely always in two, one in English and one in the vernacular language, wherever this defendant is last known to have been. So that is substituted service. The effect of substituted service shall be as effectual as if it has been made on the defendant personally, because of the reason that if you have tried to serve somebody before already, then you have gone to the extent of putting it in the newspaper. It is taken as equal to a normal service. That is substituted. And so on and so forth. Under Order 5, if you just read through it, it has various cases. For example, where defendant residing out of India, service on a defendant in prison, service in foreign territory through a political agent or a court, then sending it to an officer in a foreign country, to a public officer, how to send it to soldiers, sailors, or airmen. It's actually quite interesting reading. I don't think your exam will go into so much of detail, but since you are going through it, you should obviously read the order in totality. That is referring to service. Now, question 6 comes to what is a written statement? When can set off and counterclaim be pleaded? Now, this entire aspect and question is referred to in Order 7, which talks about, sorry, Order 8. Order 7 was what we just now went through. Order 8, which talks about your written statement, set off, and counterclaim. So now turning to Order 8 itself. So if you notice, Order 7.11 was what we had just touched upon for rejection of a plaint. Now, if your plaint is not getting rejected, it basically means that your plaint actually continues. So in that sense, when your plaint continues, as a defendant, you have to plead your own case as well. Now, a defendant's pleaded case in a suit is known as the written statement. So in very brief terms. So now we'll come to actually what a written statement is. I will also share this one small PDF that I've made, which touches upon question number and section and order relevance in the middle to explain each particular thing. That is what I'm going through as well while explaining to you all. So I will share that through the PLEA team as well to all of you all after we're done with this. Yes. So now order 7, which is written statement. Now, when we read order 5 about summons, it said that in fact, 1 itself said that the defendant's written statement within 30 days, if any. So even over here, Order 7, Rule 1 itself says written statement, the defendant shall within 30 days from the date of service of summons on him, present a written statement of his defense. Of course, if the defendant is not able to file within 30 days, then he's allowed to file it on a separate date for reasons recorded in writing, but it shall not be later than 90 days. Now, there are cases when you've not been able to file within 90 days as well. You file your application for confirmation of delay. If the court finds those reasons sufficient, then there may or may not be some costs involved, and the suit is allowed to, in that sense, go on. So that covers Rule 1. Rule 2 says new facts must be specifically pleaded. Now, here, this basically refers to the aspect of the defendant having to bring out his own case. So, in case he raises his pleading, all matters which show the suit is not to be maintainable at first, or that a particular transaction which existed between the parties is void or voidable in the point of law, all of these grounds which he actually wants to state, he has to raise within this itself. So the section itself reads also by saying that the defendant must raise by his pleading all matters which show the suit not be maintainable, or that the transaction is either void or voidable in point of law, and all such grounds of defense as, if not raised, would be likely to take the opposite party by surprise or would raise issues of fact not arising out of the plaint, as for instance, fraud, limitation, release, payment, performance, or facts showing illegality. Now, flowing from this, sub-rule 3 says denial to be specific, which is why I'm very sure if in your internship or anywhere you'll have read a particular written statement or any affidavit in reply for that matter, there is, or even a reply to a legal notice for that matter. There will be a line which says that nothing should be deemed to be admitted for want of specific denial. That line basically means that you are saying that if I am not specifically denying something in my notice or in my reply or in my written statement here, I am neither admitting anything that has not been specifically denied. That flows from this particular rule, which says your denial has to be specific. Says that it shall not be sufficient for a defendant in his written statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. So in that sense, each and every denial has to be specific, which is why when you see any of these replies, you will see a general story of your factual background given. And then you will have this line which says that now we will deal with the plaint parawise. And then you go with reference to paragraph 1 of the plaint, the defendant, blah, 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 says so and so. So that specific denial is very important. That flows actually from this particular sub-rule. Now, then it talks about evasive denials, specific denials, particulars of set off to be given in a written statement. That is again flowing on the same fact. If the plaintiff has set off a particular portion, you have to state this. Then the effect of such set off. Then 6A says any counterclaim by a defendant or a counterclaim to be, such counterclaim is to be specifically stated. And at the same time, you have what is actually a counterclaim. I should actually explain that to you. So a counterclaim in very general means if A files a case against B, alleging that a contract has basically been breached, and therefore A is entitled to damages from B. Now B in his reply will have his side of the story. So he may say that the contract has not been breached by me, but the contract may have been wrongfully terminated by him, which is why the breaches came up on my part. So there may be something within the contract for actually claiming something due to wrongful termination. So B, in that sense, can file a counterclaim against A, in which he says that due to these actions, I am now claiming against you because you have actually been at fault with respect to this contract, and therefore I want to claim against you. So this is 6A, which says counterclaim by defendant. 6B is counterclaim to be stated. So it says that the defendant shall, in his written statement states specifically that he does so by way of a counterclaim, meaning anything that you want to rely upon as a ground in support of why you say that, you have to basically get a counterclaim now. Then defendant of default of plaintiff to reply to a counterclaim. In that case, what happens is then the court is able to deal with that counterclaim as deemed fit. For the simple reason that, again, the specific denial that has to be made by the defendant, law applies to everybody. So if a counterclaim is filed, it has to be specifically denied by the plaintiff as well. Then the defense or set off founded upon separate grounds, any new ground of defense. Then it talks about subsequent pleadings or procedure when a party fails to present a written statement called for by court. This is sub rule 10, now which says that if any party from whom a written statement is required under these provisions fails to present the same within that time, the court shall pronounce judgment against him or make such order or relation to the suit as it thinks fit. On the pronouncement of such judgment, a decree shall be drawn up, provided that further that no court shall make an order to extend the prime provided under Rule 1 of this order for filing of the written statement, which means that to actually curb a suit from going on endlessly, which in very common normal practice anyway happens, there are these periods given by which you have to finish and complete your pleading so that the matter may then go forward for trial, or some interim relief in that sense can be given. Now, if you go on to the stage of filing your written statement, more often than not, you've already passed the ad interim or interim stage, which you'll actually have an IA or something filed. So that is also there. Then that completes this question 6 with respect to this. So now 7 says, what are the essential agreements of summons? What are the different modes of service of summons? This we've already actually finished in question number 5, so I won't go on with it again. Then question 8 says, explain the properties which are not liable for attachment and sale in an execution of a decree. Now, in this section 60 talks about attachment. So we will refer to section 60, which says property liable to attachment and sale in execution of a decree. So just turn to section 60. Yes. Now, if you see over here, 61 explains which properties are liable to attachment and sale. And then there's a proviso given, which says that provided the following particulars shall not be liable, namely, and then there is a list from A till P, if I'm not wrong. So there are various properties which are not actually liable to be attached, which is what this question actually deals on. So first, to understand what is this attachment, we'll have to go through subclause 1 itself. So it says that the following property is liable to attachment and sale in execution of a decree. And then it says, namely, lands, houses, or other buildings, goods, money, bank notes, checks, bills of exchange, hundies, promissory notes, government securities, bonds, other securities for money, debts, corporation shares, and save as in hereinafter mentioned, all other saleable property, meaning excluding all of these listed from A onwards, as we'll go through, movable or immovable, belonging to a judgment debtor, or over which, or the profits of which, he has a disposing power which he may exercise for his own benefit, whether the same be held in the name of judgment debtor or by another person in trust for him on his behalf. Now, attachment, in that sense, now, just to understand very clearly, there is also a concept in CPC known as attachment before judgment. That is a temporary interim relief, ad interim relief that you can actually receive from the court, in which properties of the particular defendant may be attached, or for example, certain amounts may be brought before court, or an account may be frozen. Those are also forms of attachment as per the CPC. But here we are dealing with what property cannot be attached, because this question actually says properties which are not liable for attachment. So here it comes to these provisos. Now, I'm not going to go and read through all of them, but if you see it from A, it says necessary wearing apparel, cooking vessels, in accordance with religious use, cannot be parted with by any woman. Then tools of artisans, and where the judgment debtor is an agriculturist, then the husbandry, such cattle, seed grains, which is actually essential to his livelihood, may not actually come within attachment. Then C says houses and other buildings belonging to an agriculturist or domestic servant occupied by them. D is books of accounts. As in, your books of accounts cannot actually be taken, but your bank account itself could be frozen. That is basically how it is. Then any right of personal service. So that's the list through all of this. So this is the particular provision that you should look at, which is section 60. That covers up this entire portion with respect to attachment. Then moving further, question 9 says, what is an ex parte decree, and state the remedies available to it. Now, an ex parte decree and setting aside of an ex parte decree is given in order 9, specifically Rule 13, which has that provision and the procedure for setting aside of a decree decided ex parte against the defendant. Now, to understand in basic terms, ex parte refers to when a defendant is not present, meaning the case has been decided without the defendant being there, or without the defendant being represented, or without the defendant's pleadings being on record. In these particular cases, it's when a case is heard ex parte. Now, for this specifically, there are three things, as I'll share this PDF later also. But section 96, subclause 2, actually talks about an appeal which may lie from an original decree passed ex parte. The reason I put this here is because that section just explains if something has happened ex parte, then the procedure for appealing that. So if you read that particular section, it actually explains to you what are those circumstances. Then, of course, Order 9, Rule 13 is setting aside a decree ex parte against defendant. And separately, we'll also go to Order 21, Rule 106. So just these two first. First, open Order 9, Rule 13. Yes, setting aside a decree ex parte against a defendant. So now here, this order, this particular rule, which has two provisos and one explanation also, it says that in case a decree is passed ex parte, that person against whom it has obviously been passed ex parte, he may apply to the court by which the decree was passed for an order to set it aside. Now, if he is able to satisfy the court on certain things, one, either that the summons was not duly served, which shows again the importance of serving summons. Two, or he was prevented by any sufficient cause from appearing when the suit was called for hearing. So he has to prove he was not able to come. Then the court shall make an order setting aside the decree as against him, and it can obviously subject him to some certain costs if found appropriate. Then there's an important proviso which says that provided that where such decree is of such nature that it cannot be set aside as against defendant only, it may be set aside as against all or any of the other defendants also. So if there is a decree which actually has multiple of them involved and it cannot be set aside only one defendant, then of course, in that sense, if it gets triggered, it will trigger to all. Though these 2 points, that they've not been served properly or they were in that sense, I mean, precluded from appearing before court. The second proviso makes it clear that provided further, no court will set aside a decree ex parte merely on the ground that there has been an irregularity in the service of summons if it is satisfied that a defendant had notice of the date of hearing and had sufficient time to appear. Simply meaning that even if you can show that your summons was not served, but if court actually has reason to believe, or it is shown to the court that you had, in that sense, very clear notice that this court is going to hear this matter on this particular date because this case has been filed against you, putting it in very layman terms, then you cannot get away from that by saying that, oh, I was not served properly. Therefore, I mean, I need to come in to set aside this ex parte decree. Right. So that is Order 9, Rule 13. And I said we'll also touch upon Order 21, Rule 106, which is setting aside orders passed ex parte. So just opening that. So yeah, it reads as the applicant against whom an order is made under sub Rule 2 of Rule 105, or the opposite party against whom an order is passed ex parte under sub rule of that rule or under sub rule of 23, they may apply to court to set aside. Again, here the reason being, if the court, if the court is satisfied that there was sufficient cause for his non-appearance, whom the application was called on for hearing, then the court shall set aside. So it basically says, if that is passed ex parte, you may apply to the court to set aside the order if he satisfies the court that there was sufficient cause for his non-appearance when the application was called on for hearing. Then the court, again, if it deems fit, it can set it aside. If it wants to subject the person to costs while setting it aside, the court is allowed to subject them to costs as well. So these are those 3 particular points in which this has to happen. But again, under 106, sub clause 3 makes it very clear that such an application has to be made within 30 days. Because, for example, you cannot say that I had knowledge of an order, say on 1st Jan, but I found out that I was anyway not served. And then suddenly in June, I want to now come and say that that order could not have been passed. Because then the court will find out that though you may not have had knowledge of the case being filed against you, you very well had knowledge of this order being passed against you. So even then you have that limited period before which you can come and apply back to court. So that was covering about the point of ex parte decrees. Now, various modes of execution of a decree, which is the 10th question. In that, we will have to look at the procedure in execution, which is section 51, the powers of a court to actually enforce the execution, and order 21, which is execution of decrees. So now moving first to section 51. Also, if anybody does want to ask something in the middle, then please feel free to. Yeah. So 51, powers of the court to enforce the execution. Now, the court on an application by the decree holder. Again, once the decree has been passed, say again between A and B, if A has won the case, he has managed to prove his plaint, he has got the decree in his favor. Now, this decree to be executed, he makes an application to execute it, an execution application in that sense. So once this application is made, there is A to E, in which how the court, it says the court may order execution of the decree. It's not a shall provision, it's a may provision. A, by delivery of any property specifically decreed, as in if that decree mentions a particular property, then that property is delivered to the person who has the decree in their favor. B, by attachment and sale, or by the sale without attachment of any property. C, by arrest and detention in prison. D, by appointing a receiver, a court receiver. Or E, in such other manner as the nature of the relief granted may require. So here it basically says the manner in which the court has the power to actually enforce a decree. Because of course, now once a person files a case, you win the case, you get the decree in your favor. You have to file an application to execute that. That can be contested by the other side. There can be an appeal in the first place filed against the decree. So there are various ways to, in that sense, to keep it in a very candid manner, various ways in which you can probably delay a particular proceeding from actually being enforced or reaching the ends of justice. So because of that, the court also has powers to actually enforce such an execution. That is section 51. And then comes order 21, which is the actual execution of decrees and order of payment under decree, which is very important because if a particular party has been ordered to pay, then this is their actual payment that has to be made. So sub rule 1 over here itself is modes of paying money under decree. Now, there are various modes given. If we actually go through each of them, then it will take up too much time. But in very brief, all money that has to be paid under a decree shall be paid as follows. Either you can deposit into the court whose duty it is to actually execute that decree, or out of court, meaning to the decree holder by postal money order or through a bank. C, otherwise as the court which made the decree directs. In these three manners, there can be payments made. Then separately, it also goes on to say if the money is paid by postal money order, then accurately what should that money order or payment by the bank actually state? Like what is the constituents required, A, B, C, D. Then payment made out of court to a decree holder is given in Rule 2. Then if a court executing decree, if there is a land situated in more than one jurisdiction, then any one of the such courts may attach and sell the entire estate or tenure, as given in Rule 3. Then Rule 4 says transfer to a court of small causes. 5 is mode of that transfer. 6 is a procedure where court desires that its own decree shall be executed by another court. Then, of course, you have to, again, the copy of that decree has to go, a certificate stating very clearly that this decree has been passed by this court, but is to be executed by another court. Those are the terms. Then the court receiving copies of a decree, etc., has to file the same as per the proofs, without any proof of the decree order, for example, unless there are special reasons that are recorded under the hand of the judge, and then such proof is required. Then so on and so forth. So there is an application for execution also, which is given within this order. That starts from Rule 10. If you go through the CPC and see it, 10 is the application for execution. 11 says an oral application. Within that, subclause 2 says written applications. Then an application for arrest has to state grounds. and so on and so forth. If you go through this particular order, it has the entire procedure. So one read through of it, firstly to understand the provision, then separately whatever case laws or would have been given is the manner in which to actually go about. So moving on to the next one, which is question number 11. Now question 11 says the essentials of a valid acknowledgement. Now for this, we can see order 5, because order 5 actually talks about the summons as we just saw. So, I mean, within that, there is one particular aspect about signing while taking an acknowledgement. So, I will just go to that. Yeah, order 5, rule 16. So, person served to sign an acknowledgement. Now, this particular question, to be very honest, it says the essentials of a valid acknowledgement. Now, I mean, an acknowledgement in very basic terms in that sense is you having received a particular, since we are talking about summons and notices and everything being issued as well as ex parte, in that sense, acknowledgement is something which is essential to show that you have completed service. For example, when you send an RPAD and it gets returned, even then it has a very clear remark to state why it was returned. So in the same way as if something has been received, you'll always see a particular law firm or advocate put their either their stamp on it or they will sign saying received. They'll put the date, the time with their signature. Or at times they may state, received without prejudice or received without verifying contents. For example, you may receive, suppose a particular person has sent you original documents, then you may say received without verifying contents. And then when you go through it, you can say that I had not opened at that time. And on opening right now, it has come to notice that such and such document was missing or such and such document was not in proper order. So this particular provision talks about a person served to sign an acknowledgement. And just reading just these 4 lines to understand it says whether serving officer delivers or tenders a copy of the summons to the defendant personally or to an agent or other person on his behalf, he shall require the signature of the person to whom the copy is so delivered or tendered to an acknowledgement of service endorsed on the original summons. Very clearly saying that that particular signature has to be very clearly endorsed on it to show proof of service. That is with respect to acknowledgement. Then 12 says explain legal disability under Limitation Act. So now question 12 to be answered, the concept of legal disability under the Limitation Act, you can read through section 6. So I am also going to open section 6 once clearly to read through. Yes. So just an understanding first. Now, as I said, section 6 basically talks about it, and even 7, 8, 9 do in that sense touch upon it. Now, section 6 says 3 kinds of legal disabilities. Now, understand one thing, that disability in the general sense of the term that we've understood with respect to differently able people and legal disability is a little different thing. Legal disability in very simple terms means you are legally not allowed or legally not sufficiently entitled to or capacitated to. In very legal terms, I'm saying it, but basically it means that not legally entitled to or legally capacitated to actually institute a proceeding. That makes you legally disabled. So there are 3 kinds which are actually given in section 6. These are being a minor, being an insane, or being an idiot. These 3 are actually given in 6.1. So it says very clearly where a person entitled to institute a suit or make an application for execution of the decree is at the time from which the prescribed period is to be reckoned. 1, a minor or insane or an idiot. He may institute the suit or make the application within the same period after the disability has ceased. See, these 3 kinds of legal disabilities are given in section 6 of the Limitation Act. And just to understand a little bit further, now only a person who is entitled to the suit can claim this privilege. So first point being, if you are not entitled to actually file this particular suit or make an application to execute a decree, then you obviously cannot come under this concept of legal disability, which disallows you from doing that. Because if you're not allowed to do that in the first place, you cannot be disallowed from it in very basic understanding. Then separately, an individual who does not have the right to sue or apply to the outset of limitation but is later allowed to do so, cannot claim benefit of section 6. Meaning, you can only claim this particular benefit, as the section says, when at that prescribed time period itself, you are suffering from this legal disability. You cannot use it as a ground subsequently or later on. And it says that section 6 is applicable only when one plaintiff is an idiot, minor, or insane, or when there are several defendants and they come under the purview of disability as mentioned under this. There is one interesting article also written about this legal disability point. I will share that also in that particular PDF. It can be gone through because in that sense, it's a little point which does not come across very often, at least in practice. I mean, you don't normally see, because if there is a minor actually filing a suit, it will be represented by their guardian or some major, as we saw even in Order 7, when we saw about the particulars of a plaint and how it has to be stated. So that, so legal disability as per the Limitation Act is covering on these points. Then moving further, question 13 says, what are the preconditions to be followed in institution of suits by or against the government? Now, see, this may be from a like examination perspective, something interesting to be actually asked as a question on, because it's a little different kind of a topic. So now for this answer, there are two things you have to refer to. One is section 79, which directly talks about suits by or against the government. And second is order 27, which is again suits by or against the government or public officers in their official capacity. So first, I'll request you all to turn to section 79 of the CPC. Yes. So in this, we'll see this comes under part 4, which is suits in particular cases. This being the first particular case that we're looking at, which is suits by or against the government or public officers in the official capacity. Another type of a particular suit under this is suits by aliens or by or against foreign rulers, ambassadors, and envoys. So this particular CPC that we have and the order that we'll be going through has various cases of particular suits, which in that sense is known as, this being one special category, suits against a government. Now, under 79, it is a 3-line section which says, in a suit by or against the government, the authority to be named as plaintiff or defendant, as the case may be, shall be A, in the case of a suit by or against the central government, it shall be UOI, meaning Union of India, and B, in the case of a suit by or against a state government, then you name the state. So basically saying that if you have to file a case against the central government, the plaintiff or defendant, as the case may be, will be the Union of India. And if you're filing something against the state government, then the plaintiff or defendant will be the state. For example, if just a particular example I'm giving, there was one state's railway transport corporation, Volvo buses going up and down, which the state had a case against one of the contractors or something who were involved, one of the third parties basically involved in this entire transportation process. So if Karnataka government has to file against them, it will be state of Karnataka, obviously through that relevant ministry, versus whoever. Or for example, if this third party wanted to file a case against the government, they would have filed it with the defendant being state of Karnataka through the relevant ministry. So that is how it is in that sense given. And order 27 itself, which actually talks about this kind of a particular suit. I'd request you all to turn to that while I'm also doing that. Yes. So order 27, suits by or against the government or public officers in their official capacity. That also has to be very clearly understood, that it has to be in their official capacity. Subrule 1 talks about suits by or against the government, which we actually have just seen. Then 2 says persons authorized to act for the government. 3 talks about how the plaint should actually be. So instead of inserting in the plaint the name and description of the place of residence, sorry, I'm going to read rule 3. In suits by or against the government, instead of inserting in the plaint the name and description and place of residence of the plaintiff or defendant, it shall be sufficient to insert the appropriate name as provided in section 79, which basically refers to who actually has to be the particular representative to be named. Then 4 says the agent for government to receive process. 5 is fixing of day for appearance on behalf of the government. So the court, in fixing such a day, it can allow a reasonable time for necessary communication through a proper channel to the government, Because see, if it's a private individual, say A versus B, our favorite example, then B is an individual, understanding that way. So for him to be served and come and reply is not something that has to go through various layers of communication channel. But here, the section clearly says it shall allow a reasonable time for necessary communication with the government through the proper channel, and it may extend the time at its discretion, though it shall not exceed 2 months in an aggregate. Then 5A says government to be joined as a party in a suit against a public officer. So again, this comes to joinder or misjoinder, which I think one of the questions later on does touch upon though. But if say you are filing against a public officer, then that relevant ministry of that government should also be made a party. Then 6 talks about attendance of persons able to answer questions relating to suits against the government. So the person actually who is there, who is able to answer such material questions, the court will direct the attendance of that type of a person. Then so on and so forth. The extension of time, procedure in suits against a public officer is given in Rule 8. Then no security to be required from government or public officer in these cases. Then 8B says definition of government and government pleader. Then you have your amendments made. Yes, so that is the order 27 with respect to this particular suit being by or against the government. So that answers question 13. Now coming to question 14, examine the circumstances for invocation of revisional jurisdiction of High Court. So 14 basically is answered by section 115. Section 115 talks about revision. It's a one word, revision. And 114 before that talks about review. So before we actually understand revision, I think it is also important to read through 114 simply because it could lead to a sort of confusion. The same way as the very first thing we touched upon, res judicata versus res sub judice, there is a scope for misunderstanding in these two as well. Sorry. So if you see 114, which is review, we'll come to revision the next section just after 1 or 2 minutes. But review says any person who considers himself aggrieved by a decree or order from which an appeal is allowed by this court, but from which no appeal has been preferred. So meaning if you are aggrieved by a decree or order, you have scope for appeal, but you have not filed that appeal, or by a decree or order from which no appeal is allowed, or by a decision or reference from a court of small causes, then you may apply for a review of the judgment to the court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. Very clearly essential to understand that review goes before the same court that has made the decision. For example, if a single judge of the Bombay High Court has passed an order and that order is allowed to be challenged before a division bench of the Bombay High Court, and such appeal has not, if you're allowed to file that appeal but you have not filed, or if there is a situation where such appeal is not allowed, in both those cases, you may ask that same single judge to review his case, meaning you file a review petition before that exact same judge, setting out the grounds of review and why you are actually aggrieved. So then, of course, if you understand, sometimes it may sound a little bit foolish to even understand that if a judgment has been given, why will the same judge in that sense change his view? Which is why more often than not you file an appeal. But this provision is given and review cases do actually happen. They obviously take a very long time. Sometimes, if I may be very frank, you may actually be, rubbing a little bit on the ego of a judge too by filing a review against them. But this is a provision which is given. So if a party wants to take that circumstance, they can. So that is important to understand that review is by the same court which has passed the decree or made the order, as very clearly said in the section itself. And the court may make such order thereon as it thinks fit. Whereas revision, on the other hand, which is explained in section 115, if you see subclause 1 itself, it says the High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. So revision, understand how review was the same court hearing it again. Your revision says if the High Court can call for the case record which has been decided by a subordinate court and no appeal lies thereto. And if it is found that that subordinate court has either exercised a jurisdiction not vested in it, or failed to exercise that jurisdiction, or has acted in exercise of its jurisdiction illegally or with material irregularity. Now, three cases. I mean, one, if you have jurisdiction, but you do not actually exercise it. Two, if you don't have jurisdiction, but you still hear the case. And three, if you have the jurisdiction, but you use it irregular with material irregularity or in an illegal manner. In these three cases, the High Court is allowed to make an order by calling for the papers and proceedings of that subordinate court matter. And the proviso given says that it says that provided that the High Court shall not, be clear, it is a shall provision, shall not under this section vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. So it has to be looked at with respect to what circumstances this revision actually can happen, what types of order actually can be revised. So again, if there is a particular provision of appeal in that subordinate court before that, then the revision in that sense will not apply, because even subrule 2 says the High Court shall not under this section vary or reverse any decree or order against which an appeal lies either to the High Court or to any court subordinate that, which is why if there is no if there is a scope of appeal, then a revision in that sense may not apply to actually reverse that decree. You can file your appeal instead uh, for a revision aspect. And the last part just says that a revision shall not operate as a stay of a suit or other proceeding before the court, except where such suit or proceeding is stayed by the High Court, which is why this difference of revision and review is important to understand, that revision applies to a matter by a subordinate court. Then you can have a revision being done by a higher court. For example, even if you see in, let's say, no, this is CPC, our 138 negotiable instruments will be a different procedure. But yeah, so this is basically the concept of revision. If anyone does have a doubt about it, I will take that up a little bit later. Now, question 15 says explain a suit of civil nature with illustrations. Now, in this basically question 15, what you'll have to look at is section 9, in which, give me one second. Yeah. So the jurisdiction of a court. Yes. What is a suit of civil nature? So firstly, understand that a suit of civil nature, if I'm not wrong, I don't think it has been explained as to what exactly is civil nature in that sense. But section 9 basically says that a court has to try all civil suits unless barred. I will actually come across this in the question which talks about jurisdiction also a little bit later. I think that is there in one of the questions, or the 23rd question. But just to understand what is a suit of civil nature, in very simple terms, anything that does not have a criminal color to it is something which is of a civil nature. For example, if you have, and also understand that something of a civil nature is something whereby you are claiming damages from a private person. So if I have a contract that goes wrong, or two companies have some particular shareholding agreements or something that goes wrong, or there is any rent agreement dispute, or for example, the developer basically does not pay the tenants. All of these things come under civil natures. So what exactly is a civil suit is anything of a civil nature which is in dispute and which can lead to damages to be claimed from a particular party, as in one party is liable to compensate the other. Then a suit instituted for that is a civil suit. And in that sense, under the CPC, every court has the jurisdiction to try each and every civil suit unless it is barred. Now, that means if the court cannot take cognizance of it, for example, if there is no jurisdiction, or if, as we saw in the beginning, if that plaintiff does not actually have all of the necessary conditions required for instituting a suit, then in that sense, the court may not look at it. Otherwise, each and every civil suit is to be taken up by a particular court. Now, question 16 we've already done because res sub judice, if I'm not, was done in question 3 as well. So I'll move to question 17, which is explaining the fundamental rules of pleadings when an amendment of a pleading is permissible. So question 17 for this, we'll have to look at order 6, which talks about pleadings in general. And within that specifically 17 has amendment of pleadings. So I'll request everyone to turn to order 6 first. Yes. So order 6 itself reads as pleadings generally, which is what the question is. Explain the fundamental rules of pleadings and when is the amendment of a pleading possible. Okay. So now, if you see rule 1 itself, it says pleading shall be in plain or written statement. Basically meaning that how you have a pleaded case of both sides. So it is the plaint of the plaintiff and the written statement of the defendant. Everything together is called the pleadings of the matter. Now, when you have some interim applications filed in the middle, you will have those affidavit replies, any documents that a particular party brings on record. In case there was a court commissioner appointed, then any, in that sense, those entire cross-examination conducted by him will form part of the pleadings. So the entire factual matrix, entire paper record of the case in general terms is known as your pleadings on record. Now, subrule 2 says the pleading is to state material facts and not evidence. So the reason being that evidence is something that comes in through your documents, documentary evidence, through your cross-examination, through oral evidence. And that is not something that comes inside with your pleadings. Because if you see your plaint will not have even the documentary evidence in that sense forms part of your plaint, but as an exhibit. If you see an index of a plaint, you will see though the whole thing is called plaint of the plaintiff and the docket at the end will say plaint, the index will first say plaint, page 1 to whatever, and then will say exhibit A, B, C, D, E. So your plaint actually is that first portion, which exhibits everything, but does not also state the evidence. You annex the evidence separately. That is what it means. Then you have forms of pleadings. So there are particular formats that you have to use. Commercial suits have a different format. A civil suit has a different format. If you want to file a summary suit, there may be a different format. And this is also different for different jurisdictions. So accordingly, you have to follow the format. For example, in Bombay, the Dindoshi City Civil Court, for example, or any city civil court, they specifically require the gist of prayers at the beginning. So all your prayers which you plead, which is put at the end of your plaint, they also want that on one sheet right at the beginning. So each court, in that sense, has their own various formatting that they require. You will see even when you all do your moot courts, every competition has little nitty-gritties which are actually different with respect to your pleadings that come. Then particulars to be given where necessary, condition precedent, which basically means anything that has to be uh, performed, the occurrence of that is to be either intended or to be contested. That has to be distinctly specified in your plaint. Then the departure from any contract, denial of contracts, malice, knowledge, notice, implied contract or relation, presumptions of law. Then Rule 14 talks about pleading to be signed. Of course, that every pleading has to be signed by the party and his pleader, if any, for example. So that is to obviously show that you're authorized to file the plaint. It is actually your statement. There's a verification clause given at the end as well. Then the address for service of notice, verification of pleadings, as I just said. So you have to have at the footing. If you read sub rule 15, it says verification of pleadings. And it says, save as otherwise provided by any law for the time being in force, every pleading shall be verified at the foot by the party or by one of the parties pleading or by some other person proved to the satisfaction of court to be acquainted with the facts of the case. Reason being that everything that you are filing in that sense is on oath. You're not supposed to make false statements. Otherwise, you'll be liable for perjury. You're not supposed to, in that sense, suppress relevant facts. Otherwise, that can be a ground for your claim to be rejected. You cannot, you can't basically state something that is in that sense wrong. Everything gets notarized, everything is signed. Therefore, it is also verified at the end, where you state in clear terms that everything stated in paragraph dash to dash is true to my personal knowledge, and everything stated in paragraph dash to dash is based on legal advice, and I believe the same to be true. That has to be specifically stated because you're also, you have evidence, cross-examination, everything that happens on a particular plane. Now coming straight to amendment of pleadings, which is in number rule 17. I'll read it out first because it's just a few lines. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between parties, provided that no application shall be allowed after trial has commenced, unless the court comes to conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. Now, if you understand this, it goes back to the point we said before, that everything that you plead has to be mentioned in your pleadings in very simple things. But in case, say, you have forgotten to put something, or there is some relevant fact which you make the court find is relevant to be put inside, right? Then you are allowed to plead that. To the extent that even after your trial has commenced, if the court has come to a proper conclusion that in spite of due diligence, you could not have raised it before commencement, you're still allowed to bring it in. Of course, it is not saying that each and everything you want to amend is allowed, because even your amendment can be challenged by the other side, especially if it is something which is changing the manner of the case, or the way, or bringing something very material on record, and they do not want to get that disclosed. They will try and oppose it at the same time. But so the court has to view it on the balance of convenience to allow it or not allow. And just, I said rule 17 talks about amendment, but even 18 is important to understand because it says about failure to amend after an order. So for example, in 17, if you're allowed to amend your pleadings, but a party who's obtained the order for leave to amend, if they do not amend within time, then what happens? Then if no time is, if you do not amend accordingly within the time limit, or if no time is thereby limited, then within 14 days from that date of the order, you are not permitted to amend after expiration of such time. So meaning if the order says to be amended, say within a period of 3 weeks, then within 3 weeks, if you don't, or separately, if the order does not say any time limit, then the time granted by the statute is within 14 days of that order. So if you do not do it in this, you cannot amend it after this expiration again, unless the time is extended by the court. So you have to understand it in that sense, that your amendment happens with the discretion of the court. Only your initial pleading is solely your discretion. Anything else you want to put on record, usually it requires a court order. You can understand it from a basic way, even like that. Then, so that is amendments. Then 18 is who may be joined as plaintiffs and defendants, and what is the effect of misjoinder and non-joinder. So now question 18, for this we'll look at order 1 itself, which talks about parties to suits. Within that, we'll look at rule 1, 3, and 9 specifically. But for now, just open up to order 1. So order 1, since this question actually asks 3 things, which is 1, who may be joined as plaintiffs, 2nd, who may be joined as defendants, and 3rd, effect of joinder and misjoinder and non-joinder. So 1 says who may be joined as plaintiffs. 3 says who may be joined as defendants. So we'll first see 1. Here it says all persons may be joined in one suit as plaintiffs where, if say any right to relief in respect of or arising out of the same transaction or in a series of transactions alleged to exist in such persons, then whether jointly or severally or separately, if such persons bought separate suits where any common question of law or fact would arise, then all persons may be joined in one suit as a plaintiff. So there are 2 things, A and B. Then for defendants, it says all persons may be joined in one suit where, again, similarly, if you read the particular section, it's actually, in that sense, almost identical. Basically meaning that if you have proceedings going on, if you can join those proceedings, who all are to join as plaintiffs, who all are joined as defendants. For example, now I have a contract. In that contract, there is, I am A, I sign a contract with B, and a third party within that contract itself, not the third party, sorry, the confirming party in that contract says C. If that contract has some issue with it, and I have a claim against B as well as C, I won't file 2 separate suits. As in, I will not make it A versus B as well as A versus C. I can make it A versus B and C and make my reliefs against both the defendants. So there I have joined 2 persons as defendants. Why? Because it's the same act or transaction, and they are jointly or severally, or in the alternative, basically coming together. And it's a common law of fact, common law of question, every single thing, the dispute itself is the same. So that is for who is joined as plaintiff and defendant. And within this order one, rule 9 specifically is for misjoinder and non-joinder. Again, it's a 3-line section. It says no suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of a necessary party. Now understand this. The rejection of plaint which we went to in Order 7, Rule 11, had a particular point for misjoinder or non-joinder of a necessary party. Meaning, if there is a particular person who you had to join to the suit, but you have not joined, then that is basically saying you've not filed your plaint in that sense in a proper manner. But however, that does not mean that your whole suit will go away. For example, say if I am filing a suit against B and C, and B comes up with a defense that even D should have been added. Now, my suit still again exists against A and B, which is why it says that no suit is defeated by reason of misjoin. Though it is, understood that you're supposed to join every party and you're not supposed to miss out on joining a particular party. Even if you have not, it says that the suit shall not be defeated by reason of that, because the court may understand it's a may situation, it's not a shall situation. So the court can actually reject your suit, but the court may in every suit deal with this matter in controversy, meaning your dispute actually in the suit, so far as regarding the rights and interests of people actually before it. So that is in that sense explaining misjoinder, non-joinder. As in misjoinder is if you join a particular party who is wrongly joined, as in he's not actually liable to be prosecuted against. And non-joinder, of course, is if you don't join the party who should be joined. In both these cases, this is how the court deals with it. Then moving on to 19, which is explain consequences of appearance and non-appearance of parties in a suit. Now, in this, we have to look at Order 9, because Order 9 specifically talks about this. Yeah, Order 9, the whole order is basically about appearance of parties and consequence of non-appearance. Now, understand one thing, that how you hear in a very candid sense that there is, tarikh pe tarikh. That happens when parties either don't come to court, or a party comes and just takes an adjournment, or both the parties don't appear. Then in those cases, obviously, there is a consequence that happens for the non-appearance. So that is also referred to under this order. Now, even if you have the Barak open, I'll suggest you to just see the bold rules, what the heading of each rule itself says. You'll understand completely about what happens in these cases. So 1 itself says parties to appear on the day fixed in summons for defendant to appear and answer. So as this explains itself, on a day that is fixed in your summons for the defendant to appear, the party is to appear on that day. Then 2, dismissal of a suit where summons was not served in consequence of plaintiff's failure to pay costs. So if it is found that the summons has not been served upon the defendant in consequence of the failure to pay the court fee or postal charges, then the court may make an order for the suit only to be dismissed. Because obviously you're supposed to serve your copy on the other side. You cannot file a case against somebody and say, I'm not going to serve them either. Then 3 is when neither party appears, the suit is to be dismissed. Again, just reading these words itself makes you understand what it is. Then 4 is plaintiff may bring fresh suit, or the court may restore a suit to file. So this says that if a suit is dismissed in either of these previous 2, 1 being when the summons was not served because the plaintiff failed to pay the cost to serve the summons, or 2 when neither party appears, then in that case, the plaintiff may bring a fresh suit, or he may apply for an order to set the dismissal aside. Understand this again, that in res judicata, section 11, the plaintiff was not allowed to file a fresh suit for something that has already been decided upon. But over here, a suit is being dismissed for something like this. So it has not been decided upon. So in this case, he may be allowed to file a fresh suit. Here, res judicata won't apply. Then 5 is dismissal of a suit where plaintiff, after summons returned unserved, fails for 7 days to apply for fresh summons. So even if a party has been served with summons, but the defendant has not um, received it, once that comes back unserved, it is still the plaintiff's duty to ensure that he serves it again. So that responsibility in fact stays on him. Because if you filed a case, you cannot let your case also linger in court forever. It's your duty also to see that your case is heard. Which is why when you'll go into practice later on, you'll notice that if you're on the defendant side, there are many cases where interim relief may be granted and you are more than happy as a defendant to just let the case drag on. But if you're the plaintiff, you will not be happy if I mean, obviously, if the relief is against you, or if your case is not being heard, or the defendant is just never appearing. As a plaintiff, you will usually want your case to always go on. You don't want it to obviously linger. Then procedure when defendant appears on day of adjourned hearing and assigns a good cause for the previous non-appearance. That is rule 7. Then 8 is procedure where the defendant only appears. So if the plaintiff does not appear, then the court can make an order that the suit be dismissed unless the defendant admits the claim. Now, this is actually as laughable as it sounds. This is really what the section itself says. If a plaintiff doesn't appear, you won't normally see a defendant actually admitting its claim. But for example, say there's a written statement filed by the defendant. The pleadings in that sense are complete. And then the plaintiff does not come. But the defendant's words are already on record. He's already accepted whatever he's accepted. So even if the plaintiff is being dismissed, if the defendant is liable and guilty for those particular points, then the court will obviously pass order in that sense. Then a decree against plaintiff by default bars a fresh suit. This again is coming back to what I just spoke about. Here, just above, I said that if it is dismissed for default, uh, for the example of that payment of costs or something, here, this particular sub-rule 9 says where a suit is wholly or partly dismissed under Rule 8, meaning when the defendant only appears. Then the plaintiff is precluded from bringing a fresh suit. Why? Because here, obviously, if the plaintiff themselves has not come in and then the suit is being dismissed, you cannot come and file a new suit. Then your res judicata will apply in this manner, that because it has been dismissed for your own default, we are not going to allow you to file a new suit again. Then procedure in case of non-attendance of one or more of several plaintiffs. Same with several defendants. Then 12 says consequence of non-attendance without sufficient cause shown of a party ordered to appear in person. This is the answer that you are actually required. The consequence of non-attendance. Here it says where a basic sense, where a plaintiff or defendant has been ordered by the court to come and appear. If you do not appear in person, and at the same time you do not show sufficient cause to give your reason for why you fail to appear, then you are subject to all the provisions of the foregoing rules which are applicable to plaintiff and defendants who don't appear. So you are liable to what is stated for somebody who does not appear in the court. That's your consequence of non-appearance if you've been asked to, but you still don't appear. And if you notice, in the little bit before we spoke about setting aside of ex parte decrees, that happens to be the very next rule. We are in order 9 right now. I just read out order 9 rule 12, which is consequence of non-attendance. Order 9 rule 13 is setting aside of an ex parte decree, because order 9 as a whole obviously talks about the appearance and effects of non-appearance. So that way you see everything is also interlinked. Now, question 20. Last 4 questions. So question 20 says, who can apply for setting aside the sale in execution of a decree, and when can sale be set aside? Now, question 20, for this you'll have to see order 21. Now, we'll turn to order 21 first, which talks about execution of decrees. So execution of decrees and orders payment under decree. So we had actually touched upon this order before as well. But for this particular question, we'll have to look specifically to rule 89 till 92. Now, 89 is application to set aside sale on deposit. 90 is an application to set aside sale on ground of irregularity or fraud. 91 is an application to set aside a sale on the ground of the judgment debtor having no saleable interest. And 92 is the sale when it is to become absolute and when it is to be set aside. So these particular provisions is what I felt is relevant for this answer. Now, first one, 89. where immovable property has been sold in an execution of a decree, then a person may apply to have the sale set aside by depositing in court either A, for payment to the purchaser, a sum equal to 5% of the purchase money; B, for payment to the decree holder, meaning the person who's got the decree in their favor, the amount specified in the proclamation of sale as that for the recovery of which the sale was ordered, meaning what amount actually has to be recovered, less any amount which may, since the date of such proclamation, have already been received. So, in that sense, the amount that is specified for you to actually pay up, for which the sale was actually ordered, that amount you have to pay to the decree holder. Then 2 says where any person applies under Rule 90 to set aside the sale of his immovable property, which we come to later, he shall not, unless he withdraws his application, be entitled to make or prosecute an application under this rule. Meaning that if you have already filed an application to set it aside for the ground of irregularity or fraud, which is the next rule we will come to, then if a deposit is made, you cannot withdraw your application or be entitled to make or prosecute an application under such a rule. So now 90, which says about, so 89 was setting aside on payment of a deposit. 90 is setting aside on the ground of irregularity of fraud. So here, if any person entitled to share in a relatable distribution of assets or whose interests are affected by the sale, they may apply to court to set aside the sale on a ground of material irregularity of fraud in publishing or conducting it. Meaning, if a sale notice, say, has been given out to the public and there is a what's it called, material irregularity or fraud in either the publishing of that notice or the conduct of the sale as a whole, then you can file an application under this rule, Order 21, Rule 90, to set aside the sale on ground of irregularity. And here, the explanation given is important. It says that the mere absence of or defect in attachment of the property sold shall not by itself be a ground for setting aside a sale under this, which is why it is very important to understand that setting aside of a sale in that sense has to be a very important reason and actual finding to set it aside in this manner. Otherwise, it is not taken in such a casual manner in that sense. 91 Rule 91, sorry, says application by a purchaser to set aside the sale on ground of judgment debtor having no saleable interest. So a one-line explanation of it says the purchaser at any such sale in execution of a decree may apply to the court to set aside the sale on the ground that the judgment debtor had no saleable interest. Now understand this, if a decree has been passed and you are the purchaser and you find out that the person who you are buying it from themselves does not have any saleable interest in that property, you will obviously file an application to set aside that sale. That is what this means in simple terms. Then 92 says sale when to become absolute or when to be set aside. So where no application is made under Rule 89, 90 or 91, which are the three we read right now, either deposit or what is it called? Deposit, irregularity of fraud, material irregularity of fraud, or this third case where there is no saleable interest itself. So if no application is made under either of these three, or if an application is made and disallowed under these three, then the court shall make an order confirming the sale and the sale shall become absolute. So two things. It becomes absolute, one, if either of these three above provisions have not been invoked by way of filing application, or two, if either one of these three or more, as the case may be, have been filed, but they have not been allowed, then the sale is made absolute. Yeah, so one second. This was for when it is to become absolute and when it is to be set aside. Now, for setting aside, just one second. Subclause 2 says where such application is made, meaning either 89, 90 or 91. If such an application is made and allowed, meaning it has been found to be correct, such an application, then in the case of an application under Rule 89, the deposit one, that deposit is required by that rule is made within 60 days from the date of sale. Or in case where the amount deposited under 89 is found to be deficient owing to some calculations, then the case can actually be, in that set, made absolute. Third way it can be made absolute is no suit to set aside an order made under this rule shall be brought by any person against whom such order is made. Fourth, if a party challenges the judgment debtor's title by filing a suit against the auction purchaser, then the decree holder and the judgment debtor are necessary parties. Understand it this way. Execution has happened. There is a person who has purchased that immovable property. Now, if a third party, for example, say somebody who wanted to purchase it but could not finally purchase. That third party. If he is challenging the judgment debtor's title and therefore filing a suit against the auction purchaser. So he's saying you could not have bought this because the previous person had no title to even sell it to you. Then in that case, obviously, if you understand from these facts itself, the both parties, the decree holder, meaning the person who originally had the decree in their favor, which started all of this procedure, as well as the judgment debtor themselves, who is being claimed to not have title, they have to be necessary party. It cannot be the third party filing against only the purchaser, saying that you did not have you cannot buy it because somebody else did not have title to sell it to you. You have to obviously put that person as a party as well as the person who had the degree in the first place. So that is with respect to the with respect to setting aside of a sale decree. Now going to question number, what were we on? 21 now. Discuss the provisions of Limitation Act governing the condonation of delay. Now, in this question number 21, one second. So, firstly, what I've done is application for condonation of delay is actually described in order 41 under Rule 3A. So, I want to just read that first. You all should also switch to it. It is about appeals from original decrees. It basically talks about an application for condonation of delay in those appellate proceedings, but it will be of relevance to reader to understand what such a provision is. Here, see, so here if you read 3A, the reason why I'm showing this to you is because it talks about what happens if something is put after the prescribed time period and what the court can actually do in that sense. Either the court can, again, condonation of delay is something which you can in that sense not call a curable defect as such, but if you have sufficient cause shown and if you have sufficient reasoning shown to prove why you have not actually, though you are in delay, why you are not actually in that sense under delay and should still be allowed to have your matter heard, then you can file an application for condonation of delay. And the Limitation Act that talks about this is Section 5. And just reading Section 5, which is actually, this is something you will use in practice a lot. It says that Section 5 of Limitation Act says extension of prescribed period in certain cases. I will emphasize on certain points while reading it. So it says any appeal or any application other than an application under any of the provisions of Order 21 of CPC may be admitted after the prescribed period if the appellant or applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within certain period. Explanation: the fact that the appellant or the applicant was missed by any order, practice, or judgment of the High Court in ascertaining or computing the prescribed period may be sufficient cause within the meaning. Now, basically, in simple terms, again, with so much of pending litigation in our courts, if you have filed a case after a period of limitation exists, if you have breached that, then naturally the court will try and come down a little bit hard on you in the sense that the court will want to see that you have not actually, you're not trying to just, make a mockery of the system. So you have to prove sufficient cause and show it in your pleadings itself to prove that, this is why you could not come in. It cannot be vague reasonings given. And if the court finds vague reasoning given, it may dismiss your application for condonation of delay. If the court finds sufficient reasoning, but still feels you are very, very delayed, it may even impose costs on you. So Section 5, basically, the whole Limitation Act in that self is talking about periods of limitation. But with specific reference to this, Section 5 is that answer. Now, 22, which is state the general rules for calculation of period of limitation for filing suit. Now, in this part 3 of the Limitation Act, talks about the computation of period of limitation. So I'm going to open that. Now, that is from section 12 onwards, the computation of limitation period. So what you all should do is do a plain reading, for that matter, in fact, of section 12 to say around section you should actually read a little bit more. Just read through these particular provisions until the next main heading, which is part 4. So you should read part 3 as a whole. Try to read from 12 to 24, these particular sections. Even if you just read through it once, you'll understand it in quite clearly, in fact. So now computation of period of limitation means, in general sense, when does the right to sue first accrue, when you are supposed to actually, within what period you're supposed to file your case, And if you breach that case, then your application for continuation of delay has to be filed. So now 12 says exclusion of time in legal proceedings. So one says in computing the period of limitation for any suit, appeal or application, the day from which such period is to be reckoned shall be excluded. Then then 13 for that sense says exclusion of time in cases where leave to sue or appeal as a pauper has been applied for. Now, a pauper in that sense is also explained as somebody who does not have requisite funds to fight his case for himself. So he, in that sense, is not able to file his. He doesn't have the requisite funds to fight his case. Let's keep it at that. Then 14 is exclusion of time of proceeding bona fide in court without jurisdiction. So uh, the reason I'm actually reading through these sections headings itself is to show you the different types of exclusions which are actually prescribed under this limitation act, which is looked at while computing the entire period of limitation. Then 15 is excluding time in certain other cases. Other cases meaning over here it can be with respect to continuance of an injunction of an order or a suit in which notice is given for which the private consent or sanction of the government was required. Or, for example, if there is an court receiver or an interim receiver that has been appointed, then 16 talks about the effect of death on or before the accrual of the right to sue. So, what happens if a person basically passes away? Then, how does the court have to actually look into it? Or if a person against whom, if he were living, a right to institute a suit has arisen, but that period has also passed. That period has lapsed before the person dies, but now the person has died. Then how do you file your suit? Then effect of a fraud or a mistake, effect of an acknowledgement in writing. This goes back to the point which we discussed before of how the acknowledgement has to be signed, so on and so forth. So this basically talks about the period of computation, and in fact, the Limitation Act at the end, it has a schedule, and this schedule basically is the whole period of limitation. But since which actually shows each case how many years, what is the exact period. But because this question was about the computation part, that is answered in part three of the Limitation Act. But I think you should still read both together, which is part three along with the periods itself. For example, most of them you'll see the period is 3 years from which the point has come in. Then, for example, um, I will give you just some random examples. For a enforce payment of money secured by a mortgage or otherwise charged upon immovable property, there it is 12 years. Then in your testamentary matters also, you will see that you have a 12-year period. Then most of them end up being 3 years. Then you have from suits relating to torts, which is in this schedule part 7. There you'll see a whole host of 1 year or 2 years. Then again coming to 3 and 12. So accordingly, you have um, the exact number of years mentioned in the schedule, but the way to compute it is given in section 12 to 24. And now coming to question 23, which is the last one. What is meant by the jurisdiction of the court? Explain the various kinds of jurisdiction with the help of decided cases. Now, decided cases, I am not going to go into just now at this talk, but the what is meant by jurisdiction of the court. Now, in very simple terms, here what you'll have to look at is first section 6, which describes what is pecuniary jurisdiction. Then part 1 actually talks about jurisdiction. Important to know that even section 10 and 11, which we already done, res sub judice and res judicata, they both also impact the jurisdiction, uh, obviously at the crux. Then section 15 and 16. 15 is court in which the suits are to be instituted, and 16 is suits to be instituted where the subject matter arises. So just to understand this, if you heard the first thing I said and the last one, first was pecuniary jurisdiction, and the last one was known as territorial jurisdiction. The basic difference is either it is the court which has the permission to hear a particular matter of a particular value, and second is basically geographic. First is monetary, second is geographic. For example, if a certain matter has occurred in South Bombay over here, it's a civil dispute which has a certain, now you know the whole jurisdiction has changed of High Court and City Civil Court. So for my example, I'll tell you that also. So initially we had currently at least, the city civil court was hearing matters up to 1 crore, High Court was hearing 1 crore and above. And now, from literally last week itself, the precedent's ascent has come in which the city civil court is going to hear up to 10 crore and High Court is going to hear suits only 10 crore plus. So you're going to have a huge number of suits being transferred from the High Court to the city civil court. Now, this is the most classic classic example to show you pecuniary jurisdiction. The moment High Court is to hear matters only over 10 crore, everything which is less than 10 crore currently in High Court is going to be transferred to city civil court. So that is your clear example of how pecuniary jurisdiction works. And as far as territorial jurisdiction goes, you have in Mumbai various city civil courts. You have a city civil court which is in Fort. You have a city civil court which is in Dindoshi. Now, the difference in why one matter will be filed in Dindoshi and why it will be filed in Fort is the place where the entire dispute arises. For example, if it's an immovable property, where exactly in Mumbai does that exist? Accordingly, you will file your case in whichever jurisdiction. Same way for small causes courts. There is one in Dhobi Talab area right near Xavier's school, and there is one which is in Bandra as well. So you have two different of those small causes courts as well. So it's the territorial jurisdiction that matters. So that is the basics of jurisdiction, these two. So that answers these long answers. Now, these short answer questions which are given, which are 10 of them, if I'm not wrong, we've covered all of them. Foreign judgment marks, I think foreign judgment was only the term, but that basically means a judgment passed by a foreign nation. There are some countries with which India has a particular signed agreement wherein I mean, for example, in your moot courts also, how you see, you use foreign judgments for some persuasive value. So say if the Indian statute is not explaining a particular term, but a foreign statute, or how you have these various dictionaries by these famous authors, which can be looked at to understand the interpretation of a term. That is where the foreign aspect comes into CPC. Then pecuniary jurisdiction, we've just explained. Misjoinder of parties, we've done. Transfer of cases, we've done. Place of suing comes, again, this jurisdiction aspect, section 15 and 16. Counterclaim, we've explained. Affidavit basically refers to anything that you make, any written statement made under oath on a particular stamp paper, which has to be not necessarily on a stamp paper, but which is notarized. It's any pleading that is made on oath. Your affidavit in reply, your affidavits that you in general make. You can have, say, even an affidavit of declaration made. Or if you have two names, then you make an affidavit stating that both these names are actually me. So that's your basic meaning of an affidavit. It has to be signed. It will have a attestation done. It will have a notary done. It's your oath statement. You cannot lie on affidavit, basically. Attachment we've discussed. Interim order. So interim order basically refers to something that happens before the matter is completely disposed and before the final hearing is done. So if you have a suit, which I'll explain suit because the whole CPC in that sense, we've been discussing the suits and the whole procedure. If a suit has been filed and you have, say, prayer clause A to E, you may have a prayer saying, for example, to say you have a case of damages and your claim entirely is to basically receive the goods which have actually been taken away from you. Let's take that as an example. That may be your final relief. Your interim relief can be what? Either all those goods to have a court receiver appointed, meaning that a court agent will be there to make sure that those goods are not used. Or maybe the value of those goods, that much amount to be deposited in court. That may be an interim order that you can receive in your favor. So something which comes in the interim state. And then kinds of jurisdictions we've done. So in that sense, this question matrix that was given, we've covered all the aspects. Again, of course, you will have a lot of case law involved, a lot more details which you will read. But as a general understanding, I hope I've been able to at least show you all what points to look at. And that PDF also I will share. While going through, I've realized there are some additions that I do need to make. I'll make those and I will share that we'll share it with you all. So
Thank you so much, Yazad. It was an amazing session. Thank you so much for providing the bird's eye view on the subject. And
yes.
that too at such a short notice.
No, not at all.